Welcome to our Legal One webinar, Pandemic Response. It's part of our ongoing series to try to support you in the field as you're addressing these incredibly challenging issues. Today, we're focusing on addressing HIB and discrimination claims. As many of you know, my name is David Nash. I'm the director of the Legal One program, and very happy to have with me Rebecca Gold. Rebecca has just been a wonderful partner in working with us on our webinars and working with us on so many of our ongoing professional development programs. So Rebecca, thank you for being here as well.
Thank you. Good to hear you, and good that you're all on today. Welcome, everyone.
So as we get ourselves started today, many of you have been part of Legal One presentations in the past. Of course, we're not giving legal advice during the presentation, but we are trying to give you the best information available to help you as you're thinking through how to address complicated issues related to dealing with HIB claims during this difficult time. As I mentioned, today's session is part of an ongoing series of free webinars that we are providing. So for those who might have missed it, we did offer a webinar March 18th that was an overview of issues to think about regarding coronavirus in our schools. On March 30th, we offered a webinar on defining essential personnel and functions, which is now archived and available. We offered one yesterday, April 1st, on meeting the needs of special education students. After today, we also are offering additional sessions. On April 6th, we'll be offering a session, a free session, in partnership with the New Jersey School Counselors Association on addressing student mental health and counseling needs. We are finalizing plans for another session, and we'll send out a broadcast email regarding that. It's looking to be on April 7th from 2 p.m. to 3:15. in partnership with the New Jersey Department of Education, and we know that everyone in the field has been waiting for additional guidance on issues of observation and evaluation. So we're hopeful that we'll be able to offer this webinar April 7th, 2 p.m. to 3:15. We will be sending out a broadcast email regarding that and the partnership with the New Jersey Department of Education to put that information out for the field. We are also going to be offering yet another free webinar on April 8th on addressing FERPA and student confidentiality, and trying to help folks understand the important balancing act when it comes to protecting student confidentiality, but still providing essential services for all of our students. So today's topic is really helping you to think through how do we deal with issues of harassment, intimidation, and bullying at this time. And we're going to walk through some key elements as we think through this particular issue. There is a duty of supervision that still applies. Schools are technically in session. We are in a world of remote instruction right now, but schools are operating. So we're going to talk about that duty of supervision and think about how it applies in the current setting. We're going to talk about applicable law. New Jersey's anti-bullying Bill of Rights is in effect as we speak, and we certainly could have potential issues that arise. We're going to talk about addressing issues that we learned about prior to the statewide school closure and what we should be doing to address those issues and new issues that are arising since we have all gone into the statewide school closure. We'll talk about the complicated issue of doing an investigation. You know, when we first were looking at the statewide school closure, we were hopeful that perhaps this would be very short term. It's looking more and more likely like we will have an extended school closure for a significant period of time. And we're not going to be able to simply put off HIB investigations. So we're going to talk about some strategies and some ways for you to think about how to effectively conduct those investigations and write reports that we still have to write and make sure that we are fully addressing the issues in those reports. We'll talk about requirements for state reporting and getting information to the New Jersey Department of Education and everybody's role, the role of the superintendent, the Board of Education. We'll of course talk about the role of the anti-bullying specialist, principal, anti-bullying coordinator, parental and student rights, when we have to involve law enforcement, and there are requirements that are still in effect, how we address students with disabilities, and thinking through how we address both the student who was the offender, who committed the act of harassment, intimidation, and bullying, and students who are victims. So in today's day and age, unfortunately, we are seeing new forms of bullying. It is disturbing. We give you a link, and I should have said this at the beginning, but today's PowerPoint will be posted on the NJPSA website. We will also be posting an archive of today's webinar on the NJPSA website. So this information will be there for all of you to review. And when you have the active PowerPoint, the links do all work. So we give you, for example, here, a link to a news story that highlights coronavirus-related bullying that is happening across the country. Students, in some cases, are being singled out because they are Asian American. We have significant issues that have happened across the country. Even the CDC has put out a warning about the dangers of stigmatizing individuals related to coronavirus. So we give you in the PowerPoint a link to CDC guidance on this issue as well. Students are being targeted because of nationality or ethnicity, or for other reasons. A student is suspected of having tested positive, or somebody in their household is suspected of having tested positive, and negative information is being spread about that particular student. And unfortunately, in many of these cases, when you have harmful things being said about a student, stigmatizing that student, as we'll see, it is oftentimes going to meet the definition of harassment, intimidation, and bullying, and require us to respond as school officials. And it also is likely to be considered a bias-related act, an act that is motivated in whole or in part by one of the protected classes under our discrimination law. And when we have a bias-related act, we have additional reporting requirements to law enforcement that we have to be aware of. And in some extreme cases, we have behavior that actually could constitute a hate crime that could potentially lead to criminal prosecution. So as we think about these issues, we always have to remember our greatest duty, our duty of supervision, the duty to protect the children who we are responsible for as school officials, to protect them from foreseeable dangers. That duty does not end because we are in a period of remote instruction. We still have that same responsibility. It becomes much more complicated, but we still have to recognize that duty of supervision, and there will be times where we have information that a student is being harassed, intimidated, or bullied. And we have to act. That duty does, it has for many years, extend to conduct away from school grounds as well. So we have a case that goes back 50 years to 1970, the RR versus Shore Regional case, where our court said that school officials have the right to address behavior that occurs off school grounds if it's going to cause substantial disruption for a student. And in that particular case, of course, it was a student who was going to be substantially disrupted when he physically came into a school building. One student threatened another with a knife, and the student was fearful. And now the district took action because you shouldn't have one student causing another to be in fear in school. But the same can be true when students are working from home remotely. You still have, with social media, significant ongoing harm that can happen to a student. So New Jersey Administrative Code has for many years also spelled out that we have a duty to address conduct away from school grounds. And the famous case of LW versus Orange River, it's a 2007 case, makes clear that school districts are liable for student-on-student harassment under the New Jersey law against discrimination when a student is targeted because of a protected class, and we'll walk through a little later some of those protected classes, and the school district knew or should have known of the harassment and failed to take action reasonably calculated to end the harassment. So there will be times in this remote setting where school officials know or should know that we have a student who is being victimized, and that student might not only be protected under the Anti-Bullying Bill of Rights, they might also be protected under the New Jersey law against discrimination. So let's think about our duty of care during this school closure. So for example, let's say we have a student who is non-responsive. We've now been in this closure for a couple of weeks. You have a student who simply is not responding to any of the schoolwork, is not responding to outreach that's coming from the teacher or counselor or others. We don't know why, but we do have a duty to investigate. We do have a duty to try to figure out why that student is not being responsive. And there could be a million different reasons given what's happening right now. One of those reasons could be that the student is being harmed by another student. So we have that duty to investigate, to follow up with the parent and be persistent. We know how many different issues families are juggling right now, but that doesn't excuse us from our responsibility to follow up when we have a student who is not being responsive, is not doing the work that we're asking that student to do. And that could be a signal that a student is in trouble. So following up with that parent, and in extreme cases when there's no response and we've exhausted all of our avenues, we might be reaching out to local law enforcement to make sure everything is okay in that home. So student verbal or electronic communication with a teacher, with a counselor, with other school officials could give us notice of a possible issue. Even if, as we see in many cases, the student is not very specific. The student is talking about how they are very upset about some issue that happened, sort of intimating that the issue might have involved another student. They're being vague. Again, we're not mind readers. You don't know for sure based on that information that you have a bullying issue, but you know enough to follow up, to engage in due diligence, to try to get to the bottom of what the underlying issue really is. Of course, we still do have parents who are, very specifically reaching out to school officials. And even in the middle of this terrible pandemic, we have parents who are also letting school officials know about bullying issues that are happening. And we do have a legal obligation to address that. We might also learn about bullying issues through a post that we happen to see on social media or something that's shared with us by a staff member, by a parent, by a student. And that could give us an indication that we have an issue that has to be investigated. So the anti-bullying, yes.
Dave, we have a question that fits right in here.
Go ahead.
Because of the quick closure and everything that happened on, at the end of the week of March 13th, a lot of the anti-bullying specialists are having trouble getting back into their buildings. A lot of the buildings were empty, they were cleaned, and they were pretty much sealed. And the question is that a lot of the investigations were sitting on that ABS's desk in a lot of different places.
Sure.
What is the obligation if they can get in the building even for 5 minutes, or the custodian can even get the stuff off their desk? It's one thing, but if they can't, what are the suggestions for somebody who left all of their investigations on their desk?
So, not surprising, right, that in the middle of this, there could be critical files that were left behind. What we need to do is to make sure that the anti-bullying specialist is being proactive, is reaching out to the school principal, reaching out to other administrators, reaching out to the anti-bullying coordinator in writing, and of course, picking up the phone and calling, and explaining the situation and explaining what is going on and the fact that there are essential files that are in that building. The CDC has laid out protocols. School districts have protocols in place if there are essential files that need to be picked up from a school building. We know that parents are, in virtually every school, still coming to various school sites to pick up food. In many districts, parents are coming to various school sites to pick up electronic devices for students. And staff members are coming for various purposes as well. But you shouldn't just show up at the building. We have to have strict protocols in place to make sure that the staff member is not endangering herself or others So you want to make sure you work through the principal, work through the anti-bullying coordinator and other administration, and arrangements should be made if these are essential files that you need to get to be able to access those particular files if they are hard copy.
And we have one more quick one in reference to cases. The DCPP has not been receptive to these types of follow-ups in regards to any of the cases. It's been very difficult. A lot of the state-run agencies and agencies in general have been told no face-to-face, don't go out, things like that. So what is our suggestion to that?
So is the question about somebody, go ahead.
I'm sorry, the question is basically if they've not been receptive to filing the reports and helping them with a follow-up, an investigation possibly, then what would we do? Just document that we tried to reach them?
Very important to document at least, potentially superintendent as well, the efforts that you're making and the fact that there is an ongoing investigation that has not been completed. Our hope is that after today's webinar, you'll have some additional information so that school officials across the state broadly recognize that we can't simply leave things in limbo, that we do need to show due diligence to follow up. So I think that's the best set of steps that you can take at this point. And again, you're not on your own just going to show up at a building. We need to make sure we're following all safety protocols and doing it in a way that does not endanger your own health and safety.
And another good add-on that somebody just suggested is to reach out to the school's attorney and make sure they're on board and know what's going on so they can give legal guidance.
Yeah, we always encourage school officials to touch base with their school attorney. These are complicated times, unprecedented times, and we are looking to figure out the best way to apply existing policies to a situation we never expected that we would be in. So it's a good idea to do that, but keep in mind that in just about every district, there's a strict limit on who is allowed to speak to the board attorney. So that's probably going to be the superintendent and a small group of administrators who have that ability to directly touch base with that school attorney.
Thank you.
So a couple of quick points. Keep in mind the HIB definition. It certainly could include, in addition to gestures, written and verbal and physical acts, it can include electronic communications. So that's more likely to be what we see now, although all those other things can still happen. It's not as if children are never leaving their home. So we certainly could still have written, verbal, and physical acts. It could be a single act. Oftentimes, by the time we find out about it, it's been a series of incidents. And of course, it can take place off school grounds. It needs to be motivated by an actual or perceived characteristic. And again, we've seen with the coronavirus, a stigmatizing of students from certain nationalities. And that has been one form of bullying where there has been an uptick. But it could be any of these examples, or it could be other distinguishing characteristics. We've seen kids singled out for being vegetarian, a student who came to school with lice, students who are overly quiet, the new kid in the school, somebody being made fun of because of their parents. So we want to, again, just remind folks of those key elements of our definition. You have to have substantial disruption. It only has to be for one student, and it can be subtle. It could be a change in demeanor, it could be increased fear and anxiety, and we'll talk about how we can determine some of those things. But it does need to be something more than just a momentary annoyance, because we all have those, unfortunately. It needs to be something a little more lasting. So it has to have the effect, it has to meet one of these other three conditions as well. Create actual physical or emotional harm to the student or damage to the student's property, or a reasonable fear of harm to student or property, or have the effect of insulting or demeaning the student or group the student's part of, or create a hostile educational environment for the student. And again, we can have a hostile virtual environment. Even though we're not physically together, students are still interacting with each other. Some of the great instructional practices we have going on, we still have a great deal of student engagement. and you certainly can still have a hostile environment remotely and virtually. So we do want to be aware of that. And you have to know your policy. So about 2 years ago, the State Board of Education adopted a new regulation that gave an option to local school districts. And that option, which districts would have to choose to adopt, would allow the principal, in consultation with the anti-bullying specialist, to make a preliminary determination about whether an alleged incident, if true, would meet the definition of bullying under New Jersey law. So you need to know your policy on this issue. We can't simply decide as the anti-bullying specialist or as another staff member that, well, this doesn't sound like bullying, so I'm going to use my own individual discretion and decide not to pursue this matter. Unless you have this specific policy option, every specific time we hear an allegation of harassment, intimidation, or bullying, we must go through the formal investigation process. And even if you have this policy, you have to make sure that you do it the right way, that you still have the principal consulting with the anti-bullying specialist and assuming at this stage that the allegations are true and deciding if this is true, would it be bullying? So let's think about some of the different issues that have come up. Pre-closure. An alleged incident happened prior to our statewide school closure. And the school anti-bullying specialist and the principal, they weren't quite sure what to do with it. So the school still has to complete the investigation within 10 school days of when the principal initiated the investigation. A report still must be submitted by the anti-bullying specialist within 2 school days of completing the investigation. And I will say this, because there's been, a tremendous amount of confusion about this issue, and we have been trying to deal with so many things at once. If this didn't occur within those timelines, it's better late than never. It's better to still move forward and actually do the investigation than not do it. Now, again, at first, when we had the statewide closure of schools, there was hope that maybe this would be very short term and we would be able to get back into school. And there is an option built into state law for an anti-bullying specialist to write a report and indicate that additional information will be coming later and that report will be amended. That option would have been very attractive if schools were closed for a couple of weeks, and basically every report could have indicated that we will amend the reports at a later date once we're all back in school. Now that it seems likely that this is going to extend much longer than that, it is important for us to move forward with those investigations. So post-closure, we can have new issues, of course, that are arising since the statewide closure. So you want to make sure that anti-bullying specialists are aware of their ongoing responsibilities. The responsibility is still there. You didn't stop being an anti-bullying specialist once we did the statewide closure of schools, because we are still functioning. So we still need to have a system in place for timely communication. If a teacher is finding out something while they're in the middle of doing a virtual class with their students about a potential bullying issue, that teacher has a legal obligation to verbally report that incident to the principal on the same school day. So you need to make the attempt to do that, to contact the principal and make that verbal report. And that needs to be followed up with a written report by that staff member within 2 additional school days. So that responsibility still exists. The principal needs to call the parent. It's not spelled out in statute. Usually the best practice is to do that the same day, but the principal needs to call the parent on both sides, parent of the alleged victim and aggressor, and explain that there is an allegation. And the principal needs to direct the anti-bullying specialist to initiate the investigation within 1 school day. So I know how many things are on our plates right now, but we have to make sure this does not fall through the cracks, because it is an issue of student health and safety. The investigation still must be completed and a report submitted in a timely manner. The statute does allow, as I mentioned, for reports to be amended at a later date, which may be necessary in some cases, and we'll talk about that. Sometimes it will be impossible for us to complete the investigation. But we do need to show due diligence. We do need to show that we're acting in good faith to protect students And we're showing all the efforts that we're making to overcome the challenges of remote investigations. And there are significant challenges, there's no question to it. So in a moment, we'll walk through some of those challenges, but first, a quick reminder of the timelines. HIB complaint is filed, staff member has to do it the day it occurs and then follow up in writing within 2 school days. Principal initiates the investigation. By the way, you still might have enough specific evidence on day 1. Let's say there was, discriminatory language that was used. You are likely to be able to point to other provisions in your code of conduct immediately and address those. The anti-bullying specialist leads the investigation, writes the report. Superintendent signs off on any response that we're going to impose because of bullying, but the principal can impose responses because of other code of conduct violations. The board's informed of the incident, and we'll talk about that later because we are now in a period of virtual board meetings, and we'll discuss that. The parent is notified of the outcome and the right to a hearing. Parents still have a right to a hearing, even if it's a virtual hearing before the board. And then at the next board meeting, the board has to vote to affirm, reject, or modify the decision, and the parent still retains appeal rights. So easier said than done, right, in this environment. We do have significant investigation challenges to think about. So first, reaching and gaining the cooperation of key parties. Frankly, families are dealing with so many issues. Even if their child is involved in a potential bullying issue, this may not be at the top of their priority list. They've got so many things on their plate, and some of them could be incredibly serious. So we recognize that, but we have to show the effort to reach and gain cooperation of the alleged victim, of the alleged aggressor, of key witnesses. It may not be possible, but we need to show that we're working to try to achieve that. We should think about the challenges of gathering initial statements. We'll talk about that. Conducting interviews, which are going to be very challenging. Assessing credibility. When you have a student in front of you, there are so many things we can see in reading the body language of that student. It's so much easier. But we need to do the best we can, and we'll talk about strategies for assessing credibility. And determining appropriate responses. Some of the things that would make sense as far as discipline don't make a lot of sense now, as far as a meaningful consequence for a student. So we need to think differently about that issue as well. So let's break this down into each of those challenges. When it comes to reaching key parties, again, we have to show diligence. Calling parents, and if necessary, emergency contacts. We might think, boy, this isn't such a big issue. Harassment, intimidation, and bullying can be an incredibly important issue. It can lead to devastating mental health impact for a student, and it can be a final trigger for some horrific outcomes for students. So we have to recognize that and still be very persistent in reaching out to the parents. Send emails if we have to, documenting the purpose for the outreach so parents understand why we're trying to reach them. Keep very clear records of all that outreach, because we have to show our due diligence. I would be explaining the legal requirement to conduct investigations during a statewide closure. Parents might not understand that you actually still need to do this. And even if we can't get to all the parties, let's say there's a key witness or two that we're not able to talk to, we need to show that we did as much of the investigation as we could, even if not everybody is reachable or cooperative. So when we do our typical anti-bullying specialist training, one of the things that we always talk about is the importance of trying to get initial statements from students. In a typical situation, we would try to do that before a student goes home. We're not in that typical situation anymore. So initial statements are still very important. So if possible, request that the student or adult provide a written statement on the same day you learn about the incident. I would make the request. You're going to get them less often, but in some cases you will. It's important to get that initial information as quickly as possible. You want to explain the process to be followed with the parents so they understand this process that we're talking through. In many cases, we're not going to get that initial written statement very quickly, if at all. So an alternative to the written statement, or in some cases a supplement to it, could be an initial video conference or phone call. don't forget the phone. We have that technology still available to us, but a video conference would be even better. You can still see the student. You still get some of the value that you would have from a face-to-face interview with a student. So attempting a video conference with a student and allowing the student to just provide an initial statement. Kind of before we start doing any detailed questioning, before we start trying to figure out what's credible or not, letting the student speak and see what they have to say about the issue. And we'll give you some tips to sort of assess what they're telling you. Now, I would consider, and none of you should do this on your own. This is a conversation you need to have with the powers that be in your district, likely including your board attorney. But districts should consider the value that would come with recording those initial statements. You shouldn't surprise the student. You shouldn't surprise the parent. They should know if the district decides they're going to do this and make it part of their protocol. It would be a very valuable piece of evidence to help you later in assessing credibility if you have that initial recording where the student was just allowed to speak and give their side of the story. Recognize, though, that if there is a recording, that becomes a student record under FERPA, under the Family Educational Rights and Privacy Act, and the parent has a right to access it. And the district has an obligation to protect it from unauthorized disclosure to others who do not have a right to see that video. And we will be talking in more detail about issues related to FERPA in a separate webinar that we're doing next week, but just be aware those issues are triggered if you do a recording. With that said, though, there is some real value in that recording. When it comes to conducting an interview, yes.
Dave, we have a question right on that says, you said no surprises, make sure that we tell the parent. Do you need parent permission?
You do not need parent permission. And it's clear, even though this is an unprecedented situation, we have precedent from the US Supreme Court that you do have the right to interview a student without parent permission. Now, as in a practical matter, because of the environment we're in, you're going to want to notify the parent, even though arguably you may not be required to notify the parent. I would in this situation, given how extraordinary the issue is. So as a practical matter, the parent, if they don't want their child to get in front of that camera for the interview, they're going to be able to stop it. So we should recognize that.
Thank you.
Recognize that the parent is, though, likely to be there. The parent's likely to be present, on or off screen. So even if you don't know they're there, there's an excellent chance they are right there with that student. So you want to try to identify the key issues to address based on the initial statements. That's why it is valuable to either get a written initial statement or a verbal initial statement from that student so that you have some idea what the issues are, what the conflicting statements are, the areas that you need to focus on. When you're conducting the interview, you want to try to establish the parameters. So let's face it, there's an excellent chance the parent will be there, but you're interviewing the student, not the parent. And you want to still make that clear to the parent. Of course, I would go out of my way to let the parent know I'm very happy to interview you as well. If you have information that's relevant to this, we want that information, we need that information. So indicate that to the parent. When you're conducting an interview, even an awkward interview that's being done through video conference, you still want to think about some basic good strategies. You want to begin with open-ended questions. Tell me about what happened today. Tell me about how you and so are getting along. And oftentimes that's all you need. And students will start to speak and will share information. You become more specific as you need to, but even as you become more specific, you don't want to give leading questions that suggest the answer that you're looking for. You also want to be patient. And now more than ever, students and families are going through so much. It's not going to be easy to have that perfect, smooth interview. Once you actually are at this stage and getting some cooperation, you still want to be patient, and technology can get in the way. Here you might be in the middle of somebody giving you an honest, straightforward answer, and all of a sudden you can't hear them. So be patient. Try to note omissions. If the student is very carefully not talking about something, some important part of the day where an issue might have happened. Inconsistencies, you want to note those for follow-up questioning. And even as we say with live in-person interviews, if you're able to remotely have a second interviewer who is watching that interview and can communicate with you, that would be very, very valuable. It's difficult to conduct the interview and note everything that's happening from the person who is answering you. So much more challenging, everyone acknowledges it, but we still need to do the best we can to assess credibility. So here's a few basic tips that would still work here. Let's assume for argument's sake, the parent is nearby, right? And you're interviewing the student, and the student, might not be quite as forthcoming as they would if the parent wasn't right there. So everyone has to kind of acknowledge that reality. One thing you might try is asking the student to describe what happened that day from start to finish. A student who wants to be truthful, they're going to hone in really quickly on the issue that they know you're there to talk about, the bullying issue that happened online. And they're going to hone in on that pretty quickly. If they don't, and they very carefully avoid talking about that issue, that's one indicator that perhaps they're trying to hold something back. Asking the student to paint a picture of the scene. Let's say there was something that physically happened. Two students went outside. As much as we want kids social distancing, they're not always doing that. And you can certainly have physical issues that are happening between students. So you ask a student to paint a picture of the scene, describe what happened and when it happened, who was there. And if they start to paint a picture that doesn't make sense, they're describing a scene in a park that couldn't have happened the way they're describing it, that matters. So trying to get those details, that's not the sort of thing you always think through when you're coming up with a lie, describing who was there, where they were sitting. So it's important to try to get that student. And you ask the student to tell the story in reverse or out of order. Again, the student, maybe is being coached by their parent or others. Maybe they rehearsed a certain story, but they probably didn't rehearse it in reverse. And change the story in important ways when you have them tell it out of order or tell it in reverse. And sometimes we have kids who are moving down the path of wanting to admit what they did, but it's not an easy thing to do, to admit that you've done something wrong. So, asking the student, put yourself in the shoes of this other student, look through the eyes of that other student. What might they have perceived? What might they have felt when you posted this comment online, when you took this particular action? Sometimes that's an easier way for students to start to own up to their role in a particular incident. So again, we recognize this is challenging, but here's a few basic strategies to think through assessing credibility. We also still have to think through, incidents happen every day that are minor annoyances and do not cause substantial disruption. So the legal issue we're thinking about, is there evidence of a lasting negative impact beyond that moment because of the incident? So you want to make sure you did your homework. You talk to all the important parties, talk to the student. In many cases, you do want to reach out to an assigned counselor who might know that student really well. That counselor could potentially pick up when they interview the student on significant changes in that student's demeanor and the way they're responding. Obviously, you want to reach out to the parents, and if they have any relevant information, to other teachers, to a coach or an advisor who might know the student really well, and potentially even some of the student's friends. Did the student stop participating? We are in this period of remote instruction, but all of a sudden, did this student, who was a pretty good student, stop participating? There's an indicator that you might have the substantial disruption. Did the student's academic performance suffer? Was the student sad, upset, or crying? Now, again, in this particular environment, there could be a million reasons for that we all can understand. But these are triggers for us to look deeper. Is the student exhibiting other signs of that change in demeanor? Is the student actively seeking support or counsel from a trusted adult? Are the parents reporting a disruption at home? So you want to think about these kinds of questions as you're trying to make a determination. Of course, we have to write a report. The obligation is still there, and it's the anti-bullying specialist who is charged with doing the investigation, reaching a conclusion, writing that report. You shouldn't feel like you're in this alone, though. If you've got other anti-bullying specialists in your district, talk with them. Talk with your anti-bullying coordinator. Talk with your principal or assistant. It's the anti-bullying specialist who still needs to reach a conclusion. If you write a report, it can be amended at a later date when you get additional information, and that's going to become likely in many of the cases that you all are investigating. And you should make that clear in the report. So you might say we are unable to substantiate the allegations at this time, in part because we were unable to interview the alleged victim for this reason. We were unable to interview these particular witnesses. We should not, though, make a blanket decision that we're just not going to investigate anything, and we're not going to show a good faith effort to actually determine whether or not bullying occurred. So that's the mistake that we're seeing in some places where districts are saying we're just not going to do this at all. We're not going to go through any of this process, and we're going to put this on hold until we're back to our regular school environment. The superintendent and Board of Education
Dave,
have an... Yes.
Dave, before we go on a little bit, some people joined late and we have literally over 800 people on. Can we remind people again where this would be posted? A lot of questions about where our presentation will be posted.
Yes, so it's an important point. Let me just talk about that again. On the homepage of our website, we are posting all of the free webinars that are either upcoming or the ones that we have completed. So we have a link on that homepage for our webinars. And when you scroll down that page, within a couple of hours after today's webinar, and we will have posted the PowerPoint that we're using as well. So it will be available. You just go right to our homepage. You can see very clearly there the link to access the material.
Thank you, Dave.
Absolutely. So remember everybody's role in this process. The superintendent still has to sign off on any response that's going to be implemented due to HIB. And still needs to advise the Board of Education at that next virtual board meeting that we'll talk about after the ABS completes the investigation. The board is still notified about the outcome of the investigation, but remember, they don't take action yet. They've just been notified. If a parent wants it, they ask for a hearing, and the board would conduct a hearing within 10 days of receiving that parental request. At the next scheduled board meeting, the board would vote remotely now to affirm, reject, or modify the decision that's reached. So the governor has just signed on March 20th revisions to the Open Public Meetings Act that very specifically allow for virtual meetings to take place. And that's a necessity. Given the recommendations we have from the CDC, from New Jersey Department of Health, it was a necessity for us to find a way for boards to be able to conduct meetings virtually. And we'll talk about that. So the board can elect to provide electronic notice in lieu of the standard adequate notice that would have been required under the Open Public Meetings Act. We don't have to physically put notices up. It's not going to be a violation of law by providing the electronic notice. If the body is doing virtually, and the boards are going to be doing this, you limit public business to the greatest extent practical to those matters that involve the continuing operation of government and relate to the applicable emergency declaration that we're dealing with. But we are going to continue with the process for the bullying investigations. The Department of Education has provided some additional guidance. So the board should still be advertising the meeting place. Of course, it's going to still just be a virtual meeting. We're reminded, though, that you do need to provide a means for the public to comment virtually. at a meeting. So one district I know of would have individuals email in questions to a specific address, and those questions would be read at the meeting. So you need some means for remote electronic public comment. If the board currently records the audio or video of their meetings, they should continue to do so with their remote meetings. If you have to go into executive or closed session, you should use a mechanism that ensures the confidentiality of that closed session. So for that period of time, the rest of the public would not be privy to what's happening during that meeting. And of course, districts are consulting with their local council as they put in place how they're going to conduct these meetings. For your purposes, in today's webinar, you need to know that there will still be meetings and the board still has the requirement to act. So we give you some additional information from the Department of Community Affairs. New Jersey School Boards Association has also put out some good information about remote board meetings. So as we go through this process, we want to remember everybody's rights. Students have the right to notice what they're accused of and have a right to respond very specifically. Now, you don't have to tell them 2 seconds after you learn, but before you reach a conclusion, the student has a right to give their side of the story. Students have a right to feel safe. They have a right to feel secure, even while they're engaging in remote instruction. These are virtual classrooms where students are effectively in class while they're sitting in their home. And students have a right to feel safe, not to feel embarrassed, ostracized, stigmatized by other students, even during this time. And as we know, social media can extend potential harm and increase it exponentially. Parents also have rights. They have right to a verbal notice of the allegation, the written notice within 5 days of whenever the board is advised about the incident. They have a right to a hearing with the board. They have very broad access to information from the investigation if the parent asks for a hearing. So the parent would have a right to see the full investigation report with the names of other students redacted if the parent made that request. They have a right, if they disagree with the district's decision, to appeal to the commissioner, and they still have rights to appeal in state and federal court. Oftentimes there are allegations of discrimination based on disability, based on race, based on ethnicity, and we have a range of state and federal anti-discrimination laws that still apply. We have to be mindful in this difficult time about some of the special steps to take if you have a student, for example, with a disability who may have been involved in an incident of harassment, intimidation, or bullying. So the case manager should be consulted. The anti-bullying specialist is probably not going to have expertise on all of the specifics of that student's disability and how to effectively communicate with that student. So it is a good practice to consult with the case manager to make sure that you fully understand that student's needs. And in many cases, you're going to want that case manager or another knowledgeable person to help you communicate with that student with a disability. We do have guidance from the U.S. Department of Education. This is from 2014, but it's still in effect, that says school districts should convene an IEP meeting if a student with a disability is the victim of bullying. We cannot conduct remote IEP meetings unless we have parental consent. But in many cases, if you request it, you may be able to get that parental consent to still talk about the impact that bullying issue might have had on the student and to remotely have that meeting. We have to be aware of issues involving English language learners. Parents of English language learners have a right to be communicated with in a manner that is equally effective with how we communicate with all other parents. And that's obviously true if their child is involved in a potential bullying issue. We have to be mindful to a student who's ill or medically fragile. There's an excellent chance that we're not going to be able to interview that student and gather the information we need at this time from that student, and we're going to need to delay that interview. That would be a legitimate reason that you would amend a report at a later date when you are able to get that key information you need from that particular student. And we have to always have on our radar screen students with underlying mental health issues. We need to be ready to be proactive in supporting those students, whether they're the alleged victim, aggressor, somebody who was very upset about something that happened to a friend. We need to be proactive and not just wait for kids to ask us for help if we know these are kids who are struggling with underlying mental health issues.
Dave, we have one more group that we should add in light of the pandemic. We're finding in the district where I am that we have a lot of people who have just taken their families and moved temporarily to be with family in another state or another area where maybe they feel it's safer, or maybe where they feel they would have food and safety. So that now goes on that list of people that you're reaching out to, and maybe you can't find them. Maybe they're not answering, and perhaps they're not answering because they have left temporarily based on their reaction to the pandemic. So that should go on that list to give people a teensy bit of a benefit of a doubt that you're calling and maybe they're not answering because they're just not here.
Yeah, I think it's a great point, and that's very understandable, and it has happened in many cases. Of course, you do want to not assume that's what happened, right? And you do want to try to engage in some follow-up to make sure that you don't have an alarming issue in that home where there is a need for emergency services or something like that. So that can be a likely scenario in a number of cases, absolutely. So when it comes to responding to incidents, traditional consequences in many cases just won't make sense given the environment that we're in. So the New Jersey Department of Education has some great information on issues of restorative justice and helping districts think through other ways that we can have a meaningful consequence for a student who may have engaged in harassment, intimidation, or bullying. I think that's important for us to look at. Separate and apart from the pandemic we're going through, I think we want to do more to think about restorative justice. But we have to think about something that can be meaningful for that student. You do want to build in proactive follow-up for the victim and aggressor. And again, that can get lost in the shuffle given the challenges that we have right now. So it could be incredibly important for a counselor to build into their calendar. I'm going to check in on this date, on this date. These are some of the things I'm going to look for. And in some cases, to get more specific, perhaps on certain skills you're going to work on with a particular student. And that might, in some cases, involve developing a more formal support plan to make sure that we are thinking through what that particular student needs. We do have built into state law a mandate to identify the range of possible disciplinary and remedial measures that would be used in response to bullying. We do encourage you to take this document that you will have in the PowerPoint and have your own group discussion. It gives a very long list of potential remedial measures, potential consequences to consider. In this current environment, a number of those will not work. Others should be considered. So we want to give you that link to help you think through what sorts of responses make sense in the current environment. We also have to keep in mind our reporting requirements to the state of New Jersey. We still have to report incidents in the student safety data system. And the data system does have two important categories for our discussion today. One is HIB confirmed. So you go through the process and the anti-bullying specialist concludes that this was a bullying incident. The Board of Education affirms that decision. We now have an HIB confirmed case. On the other hand, you go through the investigation process, anti-bullying specialist concludes this was not harassment, intimidation, or bullying. The board affirms that decision. That's HIB alleged. Or it's possible that the board disagrees with the anti-bullying specialist. The ABS thinks this was bullying. Maybe the superintendent believes it was bullying, and the Board of Education overturns the decision. Now you would still have an HIB alleged incident because it was not confirmed by the board. We do know that the same incident might involve other offenses as well. We've seen terroristic threats that have also been part of a bullying incident, and you might have one incident that has to be reported under multiple categories. Keep in mind that data can be amended anytime prior to the final submission for the school year to the Department of Education. So if new information comes out in May, June, July, you still could amend that report from the prior year. Even if we miss that deadline and you've finalized your statistics to the state of New Jersey, if new information comes out a year later, you still want to amend the report for your district records. Also, keep in mind the affirmative action officer does have to be brought into the loop if we have a bullying issue that involves a protected class. And it only needs to be electronic communication. So electronically informing the affirmative action officer that there's an allegation, for example, linked to nationality. Students are being singled out for being Asian American. That might be an example. So you send notice of that to the affirmative action officer, who could help with an investigation but doesn't have to, who also has the opportunity now to weigh in. Let's say you find it was bullying, to weigh in on what we do about that, perhaps what restorative justice measures we might want to think about putting in place if there's a pattern happening in that school or district. And as we know, there's a long list of protected characteristics, so we give you that list here. These are the areas where you would have to involve the affirmative action officer. We also have to keep in mind that there are times that we will have to involve law enforcement. So about half of the bullying incidents statewide involve what is called a bias-related act. That means that the act was motivated in whole or in part by race, color, national origin, ethnicity, gender identity or expression, disability, religion, or sexual orientation. It doesn't have to be a crime. It doesn't have to be a hate crime. If we have any act that meets this definition of a bias-related act, the school district must report that to both local law enforcement and the bias investigation unit of the county prosecutor's office. So we don't want to lose that reporting requirement in the hectic times that we're going through right now with our virtual environment. So under the memorandum of agreement, law enforcement is also expected to report information it learns to schools regarding potential HIB incidents. That communication, again, can get very complicated in this environment, but we do want to try to think through making sure that it still happens. It's still important for you to know if there are serious incidents involving your kids that law enforcement has become aware of. If the incident involves potential criminal offenses, law enforcement has the right to take the lead, and of course, in doing the investigation, and could tell the school district to hold off on its bullying investigation. So that would be an incident or an instance where you would document why you're not able to complete the investigation now. And that would be perfectly legitimate. And then at a later date, you would be able to conclude that investigation. So in this process, everybody has a role. It's important for us to be proactive in talking with parents and students. We still want them to come forward. I know that everyone can feel overwhelmed with all the things that we are struggling with right now, but we have to keep in mind the devastating impact that bullying can have. And we can't send out the message that we're going to go through potentially a 2 or 3 month period where we simply are incapable or unwilling to act to address harassment, intimidation, or bullying. So we've got to get that message out and get parents and students to still communicate with us about those issues. We have to make sure staff members understand their role. If they become aware of an issue that the clock is ticking, they have that obligation to act immediately and inform the principal the same day about any incidents that they learn about, and then to follow up with a written report. Our anti-bullying coordinators, who I know are wearing many other hats, still have to work to reach out to the anti-bullying specialists in their district and support them, and to make sure they understand that they still have this role and they still do need to follow up on issues. School safety and climate teams have an incredibly important role in this process. We still have a school climate. We have a virtual school climate, but it is as real as the climate we would have when students are physically in that building. It might take more work for us to recognize what that climate is, but students are communicating with each other. They are actively engaging in social media, and sometimes they are still actively engaging face-to-face. And we need to be aware of that. We need to understand it. Principal has an incredibly important role in this process as the school leader to make sure that everybody knows that we still have to proactively work to protect student safety, and to make sure that the protocols, as revised, the way we're talking about now, but they're still being followed. And of course, the superintendent and board have a critical role. In some cases, we hope this doesn't happen. You know, if the process breaks down, complaints do sometimes go to the executive county superintendent's office. Last thing you want is to have the executive county superintendent coming in and looking at these issues. You want to make sure that you're still acting proactively to protect kids from HIB. And the commissioner still can get appeals, and parents don't lose their rights. And certainly the commissioner still wants to make sure that we are protecting kids from bullying issues while we're in this challenging closure. So the school climate piece is incredibly important. We just wanted to stress that for a moment. You do have a school safety / climate team that shouldn't stop functioning. Even in this environment, we should be trying to think about what we can do. Everybody needs to have something positive in their life right now. And to the extent that we can think about proactive ways to reach out to kids, to parents, to still have everybody feel like they are connected to that school and district, it is so important. And it takes more work. We need to be creative, but that team has a very important role. And that team does still have obligations. They're still supposed to receive HIB complaints and get copies of reports. They're still supposed to identify and address patterns of behavior. So we might have to start thinking about remote meetings of our school safety / climate team so that these required functions and these essential functions can still be performed. And that will take some leadership from the anti-bullying coordinator, from the principal, from the superintendent to make sure this actually happens. We do have some lessons from older case law that I think are still applicable today. For example, if you have an alleged cyberbullying incident, which we are unfortunately seeing more of, we have to show we're engaging in due diligence to figure out the source. Sometimes you have really hurtful things that are happening anonymously. So you've got to show the effort to get to the bottom of what's happening, even if ultimately you can't. You need to send that message that we are overturning every stone. We're trying everything we can, including reaching out to law enforcement to try to figure out who might have been behind a particular incident. Keep in mind that some kids are more resilient than others. The same incident might have devastated one student and might not cause substantial disruption to a second student. So we give you an example of a case where an Asian student was targeted. Student was very resilient. The incident did not cause substantial disruption for that student. It was still inappropriate. It was still addressed, but it was not harassment, intimidation, or bullying because you actually have to have more than a momentary annoyance for the student who was targeted. Keep in mind, the road to bullying can be paved with good intentions. So we had a case a number of years back where students were worried about another student's potential eating disorder and started talking to her friends and her boyfriend about that issue. And inadvertently, even though they were acting with good intentions, they caused real harm for that student. And that was harassment, intimidation, or bullying. So in this virtual environment, we have to remind kids and parents about the dangers of spreading rumors, about the dangers of spreading information that can really stigmatize and harm a student. And the amendments that we know went into effect in July of 2018 are still in effect. So for example, approved private schools for students with disabilities, don't forget your role in this process. If you have a student who you are directly serving, who is now being educated remotely, and you find out about a potential bullying incident, we have to make sure that the school district is informed about that issue and that we still follow the protocols to investigate that issue. So we give you here just a reminder of some important changes in state code that went into effect July of 2018. And we wanted to give you a reminder of some great resources that are available on the Department of Education website regarding bullying issues and regarding school climate. Admittedly, most of these resources have not been adapted to our current environment, but they still provide really useful tools that we can proactively think about adapting to our current situation. So with that, let me pause to see if we have any additional questions.
We have, yes, we do. We have a lot of questions. I've tried to group them under a topic.
Why don't you try that again?
All, can you hear me?
Yes, now I can.
Okay, great. We had a question. First of all, there's been some questions about topics that we've already done webinars on, including the homeless, the displaced, as well as some of the others. So I would suggest
Because
that
we have done,
the audience looks into our archive
yes.
because there are webinars on those things. We had a question about the statute of limitations. A parent reported that his kindergarten child was bullied, but he waited until the child was in first grade to report. Is there a statute of limitations?
So there is no statute of limitations for the school district to still have to investigate the issue. If a parent wanted to bring a discrimination claim under the New Jersey law against discrimination or federal anti-discrimination law, typically they would have to do so within 2 years. But for a school district to have to investigate, something could have happened several years ago, and we still have an obligation to investigate as long as one of the students involved is still in the school district.
Okay. We had a question. We always use principal, principal, principal in terms of notification. Can it be from an assistant principal?
So in some cases, it's going to have to be. We know that principals are juggling so many things right now, and this is just an incredibly difficult time. The statute does say principal. In other areas, it says principal or designee. I think real world, there is a recognition that there will be times where that is not possible, given all the things a principal is doing at any given moment on that particular day. But the general protocol should be principal. That's what it says in the statute.
Okay. And again, can you just please, I know it's the third time, but we have people coming in and out, tell them where they can find this PowerPoint so that they can use it for reference.
Of course. So this PowerPoint is on the NJPSA, or will be. We're going to be posting it and the archive of this recording on the NJPSA website. It's njpsa.org. On the homepage, you do see a link for our upcoming and recently recorded free webinars. And when you click on that link, you'll see upcoming sessions, and you scroll down, you will see an archive of this recording. We will also be proactively sending out to everybody who signed up today a link to the recording and to the PowerPoint. So you'll get that proactively, but it will be posted on our website as well.
That is wonderful. There was at least 10 questions that pretty much, I think, have the same answer. A lot of variations about buildings being open, about cities locking down and not thinking that possibly going to the building for paperwork is essential. All of these lead to very specific board attorney input. Can you comment on that?
Yes, so I think the underlying issue is that it's not about going to the school to get some paperwork, right? It's about taking steps to make sure that we're protecting kids from harassment, intimidation, or bullying. We are in a time where kids are undergoing incredible stress, and families are undergoing incredible stress. And an incident of harassment, intimidation, or bullying on top of everything else we're dealing with could be that last straw, could be devastating for a student. So there is still an urgency to make sure that we are addressing these issues, but you still have to keep yourself safe as well. So there are protocols that should be followed, and you want to reach out to your district to make sure you follow those as far as how you enter the building, or if something is delivered to you in another manner, perhaps by other staff who already have to enter that building. You can work through the protocols with your district, but we shouldn't decide that we'll simply not investigate because a key file is on someone's desk and we may not ourselves be back in that building for 2 or 3.
Thank you. We're good. For the other questions, some people came late. They're in the slides. Just take a look at the slides. And for the last question that just came up, give us a couple of hours to get it posted. It's not up there yet, but it will be.
Yes, and we're working as quickly as we can to give you these webinars and to get them posted so that you have access to it and you can share it with everybody else. We want to get this information out to the field and do everything we can to support you. We know how committed all of you are to supporting your students, and we want to be here to support you as you work through these difficult issues. With that, I will just point out we are doing everything we can to make other online learning available to you at this time. So included in our PowerPoint is a list of other interactive webinars that we've either recorded and are archived or are available on our website. So with that, I want to thank everybody for your incredible commitment to our kids and everything that you're doing. We are here to support you. Thank you, Rebecca, as well, for your work and helping us with all of our ongoing learning.
You're welcome. Thank you all for your time. It's really appreciated.
Thank you, everybody.